The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori?
Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Lawgic. Starting our show a little bit late tonight. If you're not in locals or whatever, you might not have realized that the reason I started late tonight was I had a wedding of a neighbor of mine whose son, same age as my son, they grew up together. So he got married tonight. It was a really beautiful affair. He's an impressive young man, and I have a lot of admiration for this young man. And accordingly, even though I'm normally when I get invited to weddings, I'll just send the wife, especially because like if it's in the middle of the week or whatever, so I'm working. So I'll just sort of send the wife ahead. But this is when I really like when Lady Lawgic mentioned to me that his wedding was this week and asked me if I was going to come. I was like, this is one I really want to go to. So there you go. Ari is married. Congratulations to the lovely bride and groom. And it was out in Brooklyn. So, and that wedding's still going on now. So I had to basically, whatever. It's a drive. It's a deal. It's a pain in the neck. I knew I was going to run late. So I was like, let me just set up for 11:15 tonight. Because with the story that broke this morning about some of the charges being dropped, I was like, or being dismissed, I was like, I have to break this down from a legal perspective for you, my fine audience. So I certainly wasn't going to take the night off. The old wedding excuse. I need to start off with one of these. I got to tell you, Melanie, this is the first time I started a show with a $100 super chat winning out there. And I thank you. I like breaking new glass ceilings. That's like a glass ceiling shatter. The first time that's ever happened in the history of the show. That I start with a $100 super chat waiting for me. So I'm almost positive. I'm like 98% sure. I don't think that's ever happened before. So thank you. Thank you so very much. I really appreciate your support of the show. Today I read the 159-page transcript between Biden and her. OMG! I cannot believe the whole world gets to see this. Biden absolutely has a problem. And the amazing thing is that Democrats see it and they're like, you have to take back what you say he didn't know his son's birthday. Because after his lawyer spoon-fed his birthday to him, he totally knew it. It was astonishing. It was astonishing. He didn't know when he died. He didn't know what year he died. I mean, it's crazy. It was crazy. He has terrible dementia. He's suffering from serious dementia. I was thinking about reading it on the air here. I haven't read through the entire thing at all. Quite the contrary, I read really just a handful of pages of it. But I was really thinking about reading on the air. I would need to do it with someone. I wouldn't do that by myself. Maybe I'll do it on playback. That's not a bad thing. That's a pretty good idea. Bring up people from the audience, because one of the things I like about playback is I can bring up people from the audience and just, do a read that way. And just sort of, I can channel my Biden and just do a read. You won't. I know what year my son died. Oh, yeah, I can see it being entertaining. I can see it being fun. Yeah. So I thank you for sharing that thought. It's really good. It's a really good idea. I should go through that. We'll see. Stay off my lawn. Anyhow, we do need to talk about the order that came down from the judge. Those of you who are confused, this is not about Fani Willis. Fani Willis' decision is still pending. This is a separate motion, which was argued all the way back in December of last year. So the Fani Willis motion was filed first in January of 2024. In December, there was a motion which was a request for request for a special demur. Now, what that means is they're essentially saying, when the defendants are bringing this motion, they're basically saying what you pled here is too ambiguous. It's too confusing. And we don't know exactly what it is that you're we can't defend because it's just the way the charges are listed. It's impossible. You can basically go anywhere with this. So we need you to specify more. And Judge McAfee gave a decision. Now, before I get into this, I want to sort something out. A lot of people are trying to, and we're going to see that he dismissed 6 of the 41 charges that are listed in the indictment. 3 of them relate to Trump. The 3 of them have nothing to do with with charges against Trump specific individually. A lot of people are speculating, what insight does this give us into what direction McAfee is going to go with respect to the motion to remove Wade and Willis? And I've heard so much speculation. I've seen some people saying this is an indication that he is going to deny the motion. And the logic is this. The logic to say that this is why this is a sign of him denying the motion is because what he is doing here, as we're going to see in this case, what we're going to see is that he it's almost like it's a tidying up of the indictment. This is not a matter of him saying this is crap, that it's a matter of him saying the way you have it here, it doesn't work. It's not like something that can work, and it's unfair to the defense to leave it like this. So the thought process I'll explain to you why people think this is indicia that he's not going to dismiss this case. It's because you don't remodel a room 5 minutes before you blow it up, right? I mean, that makes sense. There's logic to this. So you would, if you're sitting here and you're looking at a room, you're like, I don't like the way this room looks. I don't think this is, and you know that in 10 minutes, there's a wrecking ball that's going to come through here and tear the entire thing apart. You don't sit here saying, oh, you know what? I think I'm going to put a poster on that wall. I'm going to repaint this wall. I'm going to start moving the furniture over there. You don't remodel a place that's that's been condemned for destruction. You don't do that. Why would you waste your time doing that? Who the heck would do that? And it looks as if Judge McAfee here is remodeling. And maybe he's cutting off sections of the room, saying this is not good, this is whatever. Why would you do that? Why would you do that if you're about to take a wrecking ball to the entire room? That wouldn't make any sense. You're going to take a wrecking ball to the whole house, and now I'm going to change this room, I'm going to change that room in this house. Why would you do that? Doesn't make any sense. That's the logic that a lot of people who are pro Fani Willis, people with strong TDS, are using as a basis to try and build in hope that McAfee in the forthcoming couple of days is going to deny the defense motion to remove Willis and Wade. Because if you remove Willis and Wade, arguably, you're destroying the entire house, right? This will be orphaned, the case. It's basically dead. That's one argument. That's an argument to try for the people who try and take hope for Willis. That's what we could take from this motion. Here's the other perspective as to how it could mean the exact opposite. This is how it could mean the exact opposite. What happens if Wade and Willis are knocked off of the case? Well, it goes to this whole other third party. I forget what it's called. In the interview that someone actually shared with me. Let me see. I want to try and find the proper name of this because I don't want to speak out of turn. Let me see if I can find it. It was earlier today. Someone shared something with me. Wasn't you? Or was it you? Yeah, there's an agency called like for the prosecuting attorneys, which is where it ends up going. If a district attorney is knocked off a case, which has happened before, so there's an agency for it's called prosecuting attorneys, which they're supposed to like farm it out to a DA who's interested in taking the case. When McDougal was talking to Beaver Fry earlier today, I'm going to just refer to them as the prosecuting attorneys. So when McDougal was talking about that today, he said he knew of a case that got farmed out to the prosecuting attorneys 2 years ago and has been sitting there ever since. Sitting there ever since. So the point as to if you want to take indicia from this case, and we look at McAfee, from what we've seen about McAfee, he seems to be a fairly organized, well thought out judge. He definitely seems to be very intelligent. Like I said, he seems intelligent. I haven't seen any. He isn't. He is intelligent. I'm not going to say he seems. I'm going to go beyond that. He is intelligent. It's very possible that what we see happening here is this: that he knows he's about to knock Wade off and knock Willis off, which means once you knock Willis off under Georgia law, that means the entire Fulton County District Attorney is now knocked out of the case. What will happen to this case at that point is it becomes orphaned. It's not dead. It's orphaned until some other district attorney picks it up, or it's assigned to them and they take it, whatever it is. That means it's not going to be in front of McAfee, right? I mean, the chances are very high that if he's knocking Willis and Wade off, McAfee's done with this case. And some other judge, if this case ever comes back around at Trump, at Mark Roman, at Chile, at Cheesebro, all these people here, if this case is ever picked up by someone and moves forward, it's going to move on to a different judge. Well, that judge is going to sit here and he's going to assess, where is this case at? What's the status of this case? What is the status of different defendants and their pleadings and people? They're going to spend a great deal of time going through the file. One of the things they'll see in the file is there's a pending motion for special demurrer, which McAfee, if he doesn't sign off on this thing today, has never taken care of. But that doesn't exactly make McAfee look really good. And that's why even if he were to knock Willis and Wade out, that's not a nuclear bomb, which is knocking that's knocking this case out forever. If anything, it's putting it in storage, likely cold storage, arguably potentially cold storage forever. But if it ever comes back to any judge at some point and it's picked up by someone, they're going to have to deal with this mess. And he looks sloppy if he doesn't take care of this motion, which came out long before this special demurrer motion came out, long before the motion to remove Fani and Nathan. And a judge will look at that and be like, why don't you take care of the earlier motion? Why didn't you give a decision on that? What the hell is going on with that? Like, that motion's sitting out there for the last 2 years while this case has been in cold storage. That doesn't seem right. So it could really be, it's a matter of it's not a matter of we're about to destroy the entire house, so why would you remodel right before you destroy the entire house? It's like, no, you could take this as a sign as he knows he's about to put this into cold storage. And the same way when you're taking your dishes, you're taking your stuff and you put it into cold storage for a while, what you do is you sort of fold everything neatly, lay it out nicely in the box, and then pack it away. That's what this decision that he issued today was. That was the packing and storage, so that when it goes over to the prosecuting attorneys and it stays there for 2 months, 6 months, a year, 2 years, 5 years, who knows? I don't know. But when it's sitting there, that if it ever gets pulled out by someone, that all the files and everything there is neatly laid out, and all the issues that were raised before Judge McAfee have been properly addressed rather than left hanging without any resolution. So this is, from this perspective, the fact that he's taking care of this now and making sure he's taking care of it now before he issues this other decision with Wade and Willis indicates that he has a feeling that this case may go into cold storage for quite some time. So that actually should make you think that, oh my God, Willis really has 1 foot out the door. What do I take? Do I assume like the first case, like the first vision, or the second vision? I take the third one, which I say there's no way for us to know. And anyone who tells you for sure that they know is totally guessing. Totally guessing. They are. They are. There's a method that people use when they say that they know how to pick football games. I'm gonna teach you a scamming method so you can learn to avoid grifters. Okay, because and this is very relevant to what I'm describing for the last 10 minutes. Okay, this is how you know how to avoid grifters. There's a method that based to try and rip people off. That there are these different sport betting at gurus who basically say, call us up and we'll give you the top pick. We'll give you, we'll give you tons of winners and whatever, and we'll tell you who to win and who to bet on in the football and NFL, NCAA, whatever it is. So what do? How do they operate? What they do is they get 500 people to call, and they have a game playing Monday Night Football. And they tell 250 of them take the home team, and 250 of them they take the away team. They're getting the points. Take the away team and the points, and they say we'll give you your first three picks for free, no charge. Call us up, we'll help you out. So they basically they'll split the baby. They basically say, okay, the first 250 we're going to say you take the home team, and the second 250 say you take the away team. One of them is going to cover. So now you basically have half of the 500 people won from those people who won the first week. And then the next week on Monday Night Football, they'll basically take that 250 and they'll tell 125 of them, go with the home team this week. The other one's like, no, definitely go with the away team this week. And then you have 125 people after that game is played. You have 125 people who are looking like, oh my God, you're 2-0. You're amazing. Now, that 125 people who are left over, they basically, in week 3, they split them 60-60. Take the 60 you, they say take the home. The other 60, they say take the road. Each caller doesn't know that they're telling people different things. None of them know. But by the time they basically get through 3 weeks of it, now you've got 60 people there who have gone 3-0. The people who lost once or twice, they're not calling anymore. They think you suck. No, it's the people you got lucky with. Now all of a sudden, like, oh, okay, you want week 4 picks? I'm going to need you to start ponying up. You need to pony up to me $500 a week, whatever, so I can give you my picks for what's coming up in week 4. And that is the grift. That's how that grift works. So they're basically working on high volume numbers, and where you are going to end up falling out, God only knows. And there's no way to know. But it's basically they're playing the 50-50 game of trying to hope that they get, that they guess right. And if they guess right 3 times in a row, which with some people, a certain percentage, an eighth of them, they're going to end up guessing right 3 times. Those people, they're going to bleed through the nose for picks in week 4. Why am I telling you about this right now? I'm telling you how that's all a scam. What I'm telling you is this. Some people are going to scam you and say, oh, yeah, I know for sure that this is a sign that that Fani Willis has gone out. That's clearly what we take from this. Obviously, this is what we know. And others are going to say, oh my gosh, see, McAfee basically is trying to throw a bone here and cleaning hand. He's cleaning house, but he's throwing a bone to MAGA crowd to make him feel like he looks really, to make him feel like they're getting something, even though they're really not getting very much at all. And then he's going to lower the boom with them and say, ha, you lose on the Willis Wade motion. And whoever is telling you they know is full of crap, because the only person who knows why McAfee did this, because you can lay out a very strong argument, which gives you tea leaves showing that Willis and Wade are gone. You can have very strong tea leaves which show you that Willis and Wade are not going anywhere. And anyone who actually really knows is McAfee, and more than McAfee, his clerk who probably wrote some of these decisions. So maybe a handful of clerks in his office that they know why it is that he dropped this a couple of days before giving a decision that the entire world is waiting for. So, and anyone who's not working for him, anyone who's not Judge Scott McAfee or working directly under Judge Scott McAfee, and when I say directly under, I mean in the proper, appropriate way, not like people who work under Fani Willis. Anyone who's working aside from that group of people who are working for McAfee and his clerks, nobody knows why he did this. And anyone who says, "Oh yeah, I know," they're grifting, and they may get it right, and they're going to tell you this, and be like, "Oh my gosh, this person's a genius." And I'm telling you right now, it's just like those people who are guessing on the whole 50-50 with what game you should pick on Monday Night Football. It's the exact same thing. They don't know. There's no way to know, because it really both ways work. Let me catch up on some chats here that have been hanging out here. My son died at age 10, 18 years ago. I remember the date, the time, the year, and every detail. That's awful. I'm sorry. I'm really sorry. You never forget when a child dies. That's terrible. I'm so sorry. I'm sure you wouldn't. I'm sure you wouldn't. Burying a child. There's nothing more difficult than that. Larry Johnson, what odds Biden pulled off an exaggerated dementia shtick in his deposition to dodge indictments? I don't think he was worried about dodging indictment. I don't think he was worried about dodging indictment. What's an indictment going to do? He'll pardon himself. Like, seriously, what would an indictment do? I don't think he's dodging. I don't think that's why. I think we've seen the guy. I mean, there's a chance. You think he's that clever? You think if he came up with that plan, you think he would remember to go through with it? He'd probably forget it. Oh yeah, I had that whole plan where I was going to forget stuff. Okay. I need to show you. I saw a clip here. Let me see if I saved this. I saw a clip of him. I saw a clip of him talking. He's crazy. Like, he doesn't know anything. He doesn't know anything. Like, he's like literally a rambling old man. It's a miracle how they managed to pump him up with enough juice for him to actually look coherent for a State of the Union address. It's a miracle. I don't think he's going to be debating anything. I don't think he'll ever debate Trump. Georgia Prosecuting Attorneys Council. I knew it. That's it. Thank you. Thank you, Pat D. That's right. I said prosecuting attorneys. So there, I got it right. All right. Well, thank you, Pat D. Wellesley says, FYI, Hunter is bringing boxes and briefcases into the tunnel. So they should be aware of the funny things going on. I'm not a rat. And Hunter is not allowed in the tunnels, okay? Because the next thing you know, there's going to be 8 balls left around. No Hunter in the tunnels. Will the convictions of Ellis and the other dude who pled to these charges be reversed, or are they out of luck? I think they're out of luck. Also, let's not lose sight of the fact that yeah, I think that those convictions stand. I think if everything gets dismissed, I think those convictions stand. Share McAfee's interview in Locals if you want it. I'm gonna pull that up. I've seen it. I've seen it. I've heard it. I went through the 7.5 minute interview. I think it's an interesting listen, which was from like earlier in the week. Joe, did you catch the interview with the judge? Okay, everyone wants the interview. I'll do the interview before I do the decision. We'll do the interview. Everyone wants the interview. Let's do the interview. Everyone loves the interview. Everyone loves the interview. Let's do the interview. Let's do the interview. What is that? What's that? That's not it. What? That's not it. You gave me the wrong link, brother. You gave me the wrong link. It's a 7-minute interview. I'll pull it up for you. You gave me a link to Robert Gouveia watching the interview. That's not going to work for me. Would Ben-Hur? Well, I don't know. It's hard to know how Charlton Heston would handle any situation. So I'm finding the interview here. Yes. If you mean Robert Hur, if that's what you meant, not Ben-Hur, the movie. Robert Hur? I don't know. How should I know? I can't figure that guy out. Let me find it here. I'm going through my history here. See it. There it is. And I realize that I shortchanged Melody, and I feel bad. So I was playing the war horn, and I didn't even share audio. So Melody, this is for you. That was for the $100 super chat, and I owed you one of these. I sent you a $20 one, but since it's delayed, I'll give you a second one. So Melody, again, this is for you. Thank you again. All right, let's hear this interview over here. 7-minute interview. Judge McAfee calling into the Shelley Winter Show. This was earlier in the week.
Yeah, absolutely. They can get on board at keepjudgemcafee.com. And so if anyone cares about our criminal...
He's running now for election. He's so green at this. I would love to help him.
Justice system and making it...
He's got to start a website now called Keep Judge McAfee.
Better for everyone involved here in Fulton County. I'd ask for them to take a look, to join us. I'd ask for their vote and for their support.
You were handpicked and selected and put in that position by Governor Brian Kemp. So this is your first election that you've ever run, or have you been in other elections before?
No, this is the first time, and I'm looking forward to getting out there.
Last night I had which is now I guess your challenger, Robert Patillo, on, and one of the things that he talked about why he's running is because of the backlog of cases that he says the judges can help out. Criticized the fact that this case, this what we call election interference case with Donald Trump and 18 others, has moved through the courts very quickly, but there are people who are sitting in holding cells and in Fulton County Jail who have not seen a judge, and he's saying that's why he's running. What do you say to that?
Well, what I would...
that's a fair question. We closed caption this? Oh, even better.
Say is that a lot of what he shared with you yesterday about efficiency, about getting everyone their timely day in court, I couldn't agree more with that. He's absolutely right about that, but he's coming after the wrong judge if that's what he really believes. And frankly, I've got the numbers to prove it. I mean, from day one, my job was to attack the backlog, and I've done that with everything I could, and it's working. I mean, I can tell you that I inherited a docket where I was second to last in terms of the number of pending cases. In 1 year, I'm now in the top half. I'm number 6.
Pending cases. So he was one of the worst ones when it came to pending cases. He came into a docket. I mean, when he first started, so he had the second to most outstanding pending cases. So they say pending, and now he's in the top half.
6. I had 53 different murder cases when I came on board. We're now down to 25.
That's pretty good. They're probably being pled out, most of them. Most of them are probably being pled out, but that's pretty good.
We had 25 defendants that had been sitting in jail for over 1,000 days. We're down to
1,000 days is 3 years. 1,000 days they were sitting in jail.
10. So
he's down to 10. How many did he have before? 25. All right.
We had 25 defendants that had been sitting in jail for over 1,000 days. We're down to 10. So we have been attacking this backlog with everything I've got. And we've been just doing jury trial after jury trial. When you reached out to me yesterday, I just wrapped up another murder case. So all I can tell you is people maybe don't see all of the cases that I handled. Maybe one of them gets most of the attention, but the actual bread and butter of what we do and that's happening in 5A is exactly the type of work that he talked about and that I'm really proud of.
And was that your stated goal when you got put in that position by the governor, was to take care of the backlog and get people moving?
Oh, absolutely. I mean, that has been one of the most continual frustrations of Fulton County. You know, you've got a case where a victim's family is just sitting there waiting to try and get some justice in the case. And on the other side, you've got a defendant who oftentimes just, again, wants his day in court, wants to tell his side of the story, and they're just sitting there waiting. And we've got to have a system that recognizes that and people willing to put in the work to make it better. And we've got the resources, we've got all the means in Fulton County to make that happen. It's just a matter of knowing how a courtroom works, having spent a career in a courtroom, and knowing how to move those cases along. And that's exactly what I've done.
One of the other criticisms that Mr. Patillo logged last night was the fact that many judges come from the prosecution side, and so you, as a defendant, you're up against two prosecutors in effect. What do you say to that?
So, certainly he's right that a lot of judges do become or start out as prosecutors. I certainly spent plenty of time as a state and federal prosecutor. And a lot of, when you're looking at someone, and a lot of what that job is, prosecutor's job that's done well, is almost quasi-judicial, because you're not just looking out for your own case. You're not winning at any cost. It's about justice over convictions.
Yep.
So oftentimes as a prosecutor, I was looking after the defendant's case because I didn't want it to get overturned on appeal. So that mindset as a prosecutor, like I said, it's very similar in some respects to what you're doing as a judge. So that transition from a prosecutor to a judge, the right kind of prosecutor, is one that I think is very much speaks to what a judge is supposed to do in terms of seeing the bigger picture. And it's one I've tried to apply in every case in terms of approaching a case from a perspective of allowing both sides their a fair day in court. So certainly.
So and that's the kind of prosecutor I think we all wish. We wish that was the model for prosecutors. Look, I don't know if that's actually what he did as a prosecutor, but he seems to be a pretty straight shooter, this guy, from what we've seen so far. I'll tell you this much. I'm sort of torn. I'm not going to kid you. I'm torn about promoting his website, Keep Judge McAfee. I mean, I was pulling it up there. I'm gonna watch the rest of this, and we're gonna watch the rest of this in a moment. But that is the kind of prosecutor we all want. We wish every prosecutor was like, going to be aggressive and fairly aggressive and try to find justice rather than scalps. That's the way a healthy justice system. If every prosecutor was actually doing that, we would have a much, much, much healthier judicial system. Unfortunately, that's just not the nature of how things are being run presently. I need to call out over here. I need to call out J.H. Schwalbeck. I'm gonna drop a horn. Dropping 30 in a rant. Thanks for letting me joke with you last night. Really appreciate you. Beaver Fry and Makeda are amateurs. You're the king, but not a cult king. Ha 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 ha. I'm gonna tell you this. I tip my cap to you. I appreciate the compliment. I certainly would never profess that I'm better at podcasting than either of those gentlemen. We're different. We have different approaches as to what works for us. And we're going to have a lot of overlap, which is logical because, we're in one genre and all three of us genuinely like each other. So yeah, I encourage people to watch all three. But we have a little bit of a different style, but, slightly different from each other, which is consistent with personality. That's all that is. But thank you. I really appreciate it. And yeah, it's very flattering to be in the same conversation with those guys. So I think that they're very professional at what they do. So Lost in Law says, if we're starting to gatekeep who is allowed in the tunnels, can we at least ban Lizzo first? She don't fit no tunnel. She don't fit. I don't think she fit in a Hamas tunnel. And they got the deluxe tunnels there. No, she doesn't make potholes. She makes cauldrons. Yes. We should start with the gatekeeping. Did Biden get off by sniffing her? I doubt it. Let's get back into Judge McAfee here and his thoughts.
I think he's entitled to that perspective, but when you actually look at the work I've done, I think you'd be hard-pressed to find any attorney who's tried a case in my courtroom who didn't think they got a fair day in court.
We're on the phone with Judge Scott McAfee, Fulton County Superior Court judge, and has a challenge for his election, and that election is in May 21st. Let's go a little bit to the big election interference case. I do have to ask you this question. Do you feel that Patillo's run is being backed by Fani Willis, which a lot of people on my side of the fence and a lot of people I've spoken to feel that this is a pressure campaign to force you to, and I'm doing air quotes, do the right thing or make the right decision. Do you feel that way?
That's a really, really great question. It's a great question to ask him. I think he's sufficiently politically savvy to recognize that there's no way you can say yes to that question, because all of a sudden now he's now making it him versus Fani. If he were to feel that way and admit it, then it comes out as if like now all of a sudden his decision has some sort of impact from it. So it's a great question in the sense that it's a question all of us are asking. It's a lousy question as far as him being in a position where he can give us a healthy answer. Because if he claims that he feels that this was pressure from Fani, then if he decides in Fani's favor, he looks like he caved to the pressure. And if he rules against her, then it looks as if he's trying to like swipe back at her. So in that sense, it's one of the unusual, great, lousy questions. It's a great question that is lousy because you know that he has to say no. He has to say no as to like, is this challenger to his judgeship something that he believes has been thrown at him by Fani?
No, I couldn't tell you that. And I haven't met him. I haven't seen him around the courthouse. And like I said, I think he seems sincere. So I'm not the type that I'm going to presume the worst of that sort. And I'm not one to jump at conspiracy theories like that. And the biggest thing that I wanted to come on and make sure I told you today that even if it is, it doesn't matter because it is absolutely not going to play into my decision in any way. No job is worth my integrity. And
what a great answer. What a great answer. Yeah, I'm really liking Judge McAfee.
You know, when you ask that question, what I think about is I've got 2 kids, 5 and 3. They're too young to have any idea.
There's a lot of ways he could have answered this question different than how he is.
What's going on or what I do. But what I'm looking forward to one day is maybe they will grow up a little bit and they ask me about it. And I'm looking forward to looking them in the eye and telling them I played it straight and I did the best I could.
Wow. That's
a powerful. You know what? Just for that answer alone, I'm going to promote Keep Judge McAfee. I don't know how he's going to decide. I don't know if he's going to cave, but this is his website. It's both his answer and the fact that he seems to be very intelligent. That answer, is he being sincere with that answer? I don't know. There's no way I can know. I mean, what do I know about him in his personal life? I mean, he could be a great liar. He could be. It could be. He could end up being an utter disappointment and basically turn around and, cave to Fani Willis. Because if he allows Nathan Wade to remain on this case, I'm sorry, that's caving. What he does with Fani, it's a little closer. But to ignore the glaring, no, not glaring, blinding appearance of impropriety by allowing Nathan to stay on here, that would be disastrous. So I'm going to tell you right now, if you do want to help support him, he's probably going to need a lot of money in campaigns. He's probably going to need a lot of money. The website is Keep Judge McAfee, and he talks about his family here. Judge Scott McAfee devoted a career to public service, first as a state and federal prosecutor, then as Georgia's Inspector General. While at Fulton County District Attorney's Office, McAfee started in the complaint room and worked his way up to the major case division, where he exclusively handled homicide prosecutions. Wow. As an assistant USA in the Northern District of Georgia, he investigated and prosecuted major drug trafficking organizations and fraud conspiracies. Later, as Georgia's inspector, so he's familiar with people who pay cash. Later, as Georgia's Inspector General, Scott was responsible for policing allegations of fraud, waste, and corruption throughout the entire executive branch. On February 1, 2023, he was sworn in as Fulton County's newest Superior Court judge. Scott is running for election in 2024, so he continues serving our community by clearing the COVID backlog, giving everyone their fair day in court, and keeping our community safe. Scott met his wife, Danielle. Okay. While at UGA, proud parents of 2 children, ages 4 and 2. There's a cute little family. There you go. We have issues. Clear the COVID backlog, provide path forward for non-offenders. Justice delay is justice denied. I like him. I do. I like him. I'm hoping I don't regret saying that 2 days from now. It's very possible. I know it's possible. I'm going to hold back my donations. I'm holding back my donations for a couple of days. And you know what? Maybe if he gets an influx of donations afterwards, I don't know. I'll tell you this much. He clears off that backlog. Everyone's saying if he gets rid of Willis, it's gonna crush him. I don't know. I speculate just the opposite. I know thousands of people who would be very eager to help contribute to his campaign if he does right by this case. And it's like, look, that crazy hoe, she was clearly lying on the stand. Now, he's not going to phrase it quite like that because he's too political. He's too savvy. But he basically, if he gets rid of her, which is a way of saying, yeah, please go after her. Please remove her from office and because she committed perjury. Yeah, I think that will end up fattening his campaign wallet considerably. Whereas if he doesn't, if he caves to Fani Willis, I really think this can blow up. This can blow up in their face. Because I'll tell you right now, I think that if I was his political advisor and he could be bought, I'd be like, dude, if you bury her, all that Trump money is coming your way for your campaign. A lot of Trump money coming your way for a campaign. And you're going to need money now because Fani just put this guy up against you. So, but I think he really has integrity. And you know what? Most people who don't have integrity, they wouldn't think to give this answer. That's what gives me hope that this guy is legit. Like I said, do I know he's legit? No. But what gives me hope that he is legit is this wouldn't even flow through their minds as far as not sacrificing their integrity. They would be like, I don't like to speculate. Who knows? Whatever. It wouldn't even dawn on them that the notion of sacrificing their integrity or that their integrity is worth more than this. They would just be saying, I need to uphold the law, but like recognizing that his integrity is on the line and doing right and marching forward, doing the right thing without and trying to make sure that at the end of the day, when your kids grow up, you can say, I held myself in integrity and did the best that I could, is worth more than staying on as a judge. I think most people would not answer the question that way. I really think that they wouldn't, and I give kudos to him for that. 2
kids, 5 and 3. They're too young to have any idea of what's going on or what I do. But what I'm looking forward to one day is maybe they will grow up a little bit and they ask me about it, and I'm looking forward to looking them in the eye and telling them I played it straight and I did the best I could.
Wow. That's a strong, I'm editorializing here. That's a strong answer right there. And I know it's true. So on that side, can you tell us, I have got to ask this question also, can you tell us, are you any close or anywhere closer to that 2-week decision on the election interference? Are we closer to that? Are we sooner than 2 weeks or outside of 2 weeks? How are we looking?
I gave myself a deadline because I knew everyone wanted an answer. And I'll tell you, an order like this takes time to write. There's a lot that I have to go through. And so, I'll emphasize this. I've had a rough draft and an outline before I ever heard a rumor that someone wanted to run for this position. So the result is not going to change because of politics. I am calling it as best I can in the law as I understand it. So I still feel like I'm on track to having that done by the deadline that I put on myself. Today,
the news broke that the Fulton County Commission dropped any ethics hearings with a DA against DA Fani Willis because she's a constitutional officer. That was one of the arguments waged by the defendants when you had the hearings. Does that change anything based on your outline and what you've been thinking about in your decision?
Well, well, Shelley, unfortunately, I think that's where we start dipping into that realm.
No problem.
I can tell you that.
No
I
So
can
problem.
those
tell you
people
that.
will have to prevent me from doing that, but maybe we can sit down many years from now and have another conversation about it.
No problem. I had to ask.
So there you go.
Your Honor, before we get started,
Let's pause that here. All right. So that's the story there. It is an interesting interview. He seems like a really legitimately good guy, and he's definitely a very smart guy. So, yeah, I hope that we'll. I hope we see. I was going to be following this case very, very closely, and I'm going to tell you right now, I have enough confidence in him right now. I'm going to tell you that if you want to support him, if you're interested in supporting him at this point, I can understand that. You got to go to keepjudgemcafee.com. And there he is about the issues, and I'll work to provide a path forward for those who have made mistakes and have desire to become productive members of the community, hold violent offenders accountable. Guilty of violent offenses will be held accountable for their actions that our community is kept safe from violent crime. All right, so there you go. That's Judge McAfee. Let's see his decision over here with respect to where were you? Oh, there we go. Here is his decision. Okay. Here is his order on defendants' special demurrers. Defendants challenge counts 2, 5, 6, 23, 28, and 38. So they didn't challenge all of them. They challenged 6 of them specifically. And he said, an indictment by way of special demurrer. Demurrers provide means for the criminally accused to ensure that the state's charging document satisfies the constitutional mandates of due process and the Sixth Amendment. So if in case you joined late and you missed my explanation as to what a special demurrer is, it's basically a claim by the defense that it's the way these charging indictments are drafted, it's too vague. And we can't defend. It's like you always want to see where the prosecution has a duty, because of the Sixth Amendment, they have a duty to be crystal clear as to the basis on which you're being charged and what exactly it is what exactly is being laid out as far as why it is that you have to go to jail or they think that you belong in jail. So if there's any ambiguity, that has to be cleared up. And absent of being cleared up, it's got to be the charges have to be dismissed. Now, I do want to point out to you, they can bring a superseding indictment. They can reconvene a grand jury and get these charges back in if they're so inclined. And I think they likely will, but I'll get to that shortly. A special demurrer challenges the form of the indictment by claiming that the defendant is entitled to additional information or specificity, Kimbrough v. State. Pre-trial, a charging document expected to be, quote, perfect in form as well as substance. The challenge language of an indictment should be interpreted liberally in favor of the state. So, okay, there can be some sort of liberality, with any objection strictly construed against the defendant. So, just to be clear, you don't have to be something that we'll give a broad interpretation to your words when we're looking at them. Despite this, a pretrial challenge does not require showing of prejudice, and the trial court should examine the indictment from the perspective the accused is innocent, i.e., lacking knowledge of any incriminating facts alleged by the state. So that's the framework which the judge has to look at. So let's assume that you have a defendant here who doesn't know anything about this case, doesn't know why he's charged, he wasn't there for the facts. So now they need to understand exactly what it is that you're saying he's done. Our appellate courts have provided a well-used standard for evaluating a special demurrer. Quote, the test is not whether the indictment could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he must be prepared to meet. In other words, it's crystal clear that you know what's coming at you. And in case any other proceedings taken against him for a similar offense, whether the record shows with accuracy to what extent he may plead a former acquittal or conviction. You can understand why this makes a lot of sense under the whole double jeopardy element to it. If he ends up being exonerated, or at least found not guilty, if the defendant is found not guilty, and later on he's charged for similar things, he needs to know whether or not he's been charged with committing that crime. And some other prosecutor who comes along has to know that he was charged for this crime already, and that the judge would know that he's charged with this crime. But if the charging documents are not clear, then even if he ends up being found not guilty, he might end up being brought in by a different prosecutor, the same prosecutor, and they'll sort of twist around and they'll claim that he wasn't defending on charge A. He was really charged with B, and that's what he was acquitted on. But we're coming after him on A. Well, if it's left confusing as to whether it's A or B. So that's why there's a duty to make sure that this is clear and specific. Deploying a civil analogy, a special demurrer is akin to a motion for more definite statement under OCGA 91112. The ultimate purpose is to put the defendant on notice and protect against double jeopardy. All right. Turning to the indictment itself, these 6 challenge counts charge various defendants with solicitation of violation of oath by a public officer in violation of OCGA 1614-7, which is over here. We see that's charge 2. I'm going to hold off and playing. I'm going through that right now because this will take like 4 hours if I do it that way. The crime of violation of oath by a public officer prohibits any public officer from willfully and intentionally violating the terms of his or her oath as prescribed by law. The term of the oath alleged to have been violated must be expressly prescribed, meaning it is explicitly contained in the applicable statutory provisions. Okay. The 6 counts are similarly constructed and can be summarized as follows. Count 2 alleges that the multiple defendants solicited elected members of the Georgia Senate to violate their oaths of office on December 3rd, 2020, by requesting or importuning them to unlawfully appoint presidential electors. So now, so count 2, again, just to understand, what are we talking about over here? Is that you basically went to these elected members, you went to the Georgia Senate, and you said to the Georgia Senate, hey, we want your help with this election, and we want you to appoint electors. So what were you doing wrong there under charge 2? You were trying to convince them to break their oath under to uphold the Georgia state constitution, ignored their oath, and put your guy in. So this is not about the phone call. This is about that you were trying to get these people here to break their oath of office by having them basically break Georgia law and appoint the guy that you wanted. Count 5 alleges that defendant Trump solicited the Speaker of the Georgia House of Representatives to violate his oath of office on December 7, 2020 by requesting or opportuning him to call a special session to unlawfully appoint presidential electors. So that was a specific thing that Trump, when he asked him to have a special session, that was asking him to break his oath. Count 6 alleges defendants Smith and Giuliani solicited members of the Georgia House of Representatives to violate their oaths of office on December 10th, 2020 by requesting between them to unlawfully appoint presidential electors. So there's that. 23 alleges that multiple defendants solicited elected members of the Georgia Senate to violate the oath of office on December 30th, 2020 by requesting and between them to unlawfully appoint presidential electors. So all these different steps that were being taken in Georgia with the Senate or with the Speaker of the Georgia House, that all of these were steps where you were trying to get illegal electors appointed. Count 28 alleges defendants Trump and Meadows solicited the Georgia Secretary of State to violate his oath of office on January 2nd, 2021 by requesting and opportuning him to unlawfully influence the certified election returns. That's the phone call. That's count 28. The infamous phone call of find me 11,000 votes. Count 38 alleges that defendant Trump solicited the Georgia Secretary of State to violate his oath of office on September 17, 2021 by requesting or importuning him to unlawfully decertify the election. So when you're asking the Georgia Secretary of State to take away their certification, that is another purported breach of Georgia law. Defendants first argue that the indictment is defective because the charging language does not cite the oath each of these solicited public officers was required to take. Okay. This omission is legally harmless, as the code provides only one option relevant to each category of public official. So you don't need to tell me in the charging document what oath they took, because whatever, depending on their position, we can figure out what their oath took. You, the defendant, can figure out what oath they took. So that's not really something that's, so even though it might be an omission, it's harmless because you can figure it out, defense. So there's no problem here. Everyone's going to know at the end of the day whether or not what that oath was. Each Georgia senator and representative must take the oath prescribed in OCGA 28-114. The governor, in turn, takes the oath prescribed in OCGA 45-12-4. Secretary of State has the oath of 45-3-1. Without the possibility of alternative oaths prescribed by law, the court agrees with the state that defendants are sufficiently apprised of which oath is at issue in each indicted count. So in other words, they don't need to use the language of the oath because of the nature of the positions that each of these individuals who were being solicited, because the nature of their position dictates what their oath was. You, the defense, and your attorneys can figure out what oath they took that you were asking them to break. So that is harmless omission in the eyes of Judge McAfee. Even if the relevant oaths are apparent as a matter of law, defendants further contend that counts do not detail the exact term of the oaths that are alleged to have been violated. So in what way would they be violating their oaths? That's more interesting. The state first responds that defendants are only charged with solicitation, not violation of oath of office, and argues that the great weight of authority has never required charging language to reach beyond the elements of solicitation itself. So you asked them. So now the state is saying, it's enough for me to say you asked them to break an oath, and that's a crime. I don't need to say in what part of that oath was being violated. But Sanders tells us the elements of the underlying predicate felony that is alleged to have been solicited cannot be so easily ignored. In Sanders, the Georgia Supreme Court found a special demurrer should have been granted when an indictment failed to sufficiently allege the underlying felony solicited by the defendant. In particular, for an allegation of solicitation of felony drug possession, the court found that indictment should have averred the specific drug possessed and its quantity. You can't just say you have an illegal amount of drugs. You need to say cocaine in this amount, meth in that amount. You need to specify what the actual drug is. Without this information, the defendant could not prepare a defense intelligently, as the crime could be committed in a number of possible ways. Makes sense. When charging other compound crimes, such as felony murder, precedent is clear that the allegations must either include every essential element or the predicate offense or charge predicate offense in a separate count. In other words, a naked charge of solicitation cannot survive unless accompanied by additional elements establishing the solicited felony. So a charge of you were trying to get someone to do something, you need to be more specific as to what he was trying to get them to do. The same way, if the person had been properly solicited, you need to say what they had done. So too, meaning, let's just put this aside for a second so you can more easily understand this, because I want to make sure, I know this is complex legal issues, and my objective is to try and simplify it for you. So what is actually happening here is, imagine someone wants to, there's John and Billy Bob. John now wants to buy drugs from Billy Bob. Okay? He wants to buy, let's say, a kilo of cocaine. So he goes over to Billy Bob and he's like, I'd like you to sell me a kilo of cocaine. I'll give you X number of dollars for it. And Billy Bob now has this kilo of cocaine and he gives him the coke and takes the money. Whole thing is on recording. The police are monitoring everything. They go in there and they arrest them both and they charge them both, right? Let's assume that John never actually got a hold of the cocaine. He gave the money, and the guy starts handing the drugs over. The police bust in there, and there's a raid. Now, has John ever held the cocaine? No. What's he being charged with? As far as we know, he's never touched cocaine in his life. He's charged with solicitation to obtain cocaine. Now, you need to spell. So what would Billy Bob be charged with? Billy Bob would be charged with possession of cocaine with intent to distribute. Now, you need to, what would you, if you want to bring charges against Billy Bob, you can't just say possession of an illegal amount of drugs. You need to specify what the nature of the drug is, what quantity that was there, because the drug statutes are very clear as to at what point it raises up in different levels of felony based on the nature of the narcotic that you're in possession of. So we now understand that with Billy Bob, you would need to specify the drug and the quantity and basically make it clear enough that Billy Bob can know, oh, I'm being charged with cocaine, not with meth or not with whatever. And his lawyers can basically know what it is that you're claiming that he had there. Similarly, you can't just go to John in this story and charge him with solicitation to buy an illegal quantity of drugs. Because the same way when you're charging Billy Bob, there's a requirement that Billy Bob is aware as to what the drugs and the quantity are. So to solicitation of that, it requires that we also specify what you're soliciting, the nature of the drugs and the quantity thereof, as well as the time and date, all that other stuff. Okay, but you need to have that. So solicitation is going to carry with it is going to require the same need for specificity, the same need for detail, as if you were charging the other guy for violating what was being solicited. Okay, so now in this context, if we bring it back to our case, Trump soliciting from a senator to break his oath. Let's assume that the senator had broken his oath and put in improper electors or done some other way that he had broken his oath. Well, now in that context, Trump would become John, and the senator who went along with it would become Billy Bob. And what Judge McAfee is astutely pointing out is that if you're saying that Trump was soliciting from the senator, we want you to break your oath, then much as if when you're going after the senator, you have to say, this is what you broke the oath. This is how you broke. This is the oath that you took. This is the parts of the oath that you violated when you took these different steps. This is how you violated this oath that you took. So that there's particularity, specificity, detail that you can walk Billy Bob or this Georgia state senator who now has broken his oath as to what it is, what the oath was, or at least how, in what form the oath was broken. Now, we come back to John or Donald Trump here soliciting, requesting that the senator break the oath. You need to break down for Trump what part of the oath he was looking for him to break. And it all starts becoming clearer now. You can start understanding where the judge is coming from. And it's actually a very logical approach that he's taking to this. And he's like, look, so when you charge someone with solicitation, just like with drugs, so too solicitation to break an oath, you need to provide enough detail that it would work even if you were charging the guy for breaking the oath or the guy for possessing the drugs. So that's what McAfee is pointing out here. All three statutory oaths contain, with some linguistic variation, a provision that the oath taker will support the Constitution of the United States and Constitution of Georgia. The indictment, when detailing the manner and means of the criminal enterprise alleged in count 1, describes the defendants as soliciting Georgia officials to violate their oaths to the Georgia Constitution and the United States Constitution. Thus, reading the indictment as a whole, which trial court is required to do, confirms that these are the prescribed terms at issue in the 6 challenge counts. While the averments do contain a reference to the terms of the violated oath, meaning there's the averments is over here the criminal indictment, the different statements in here are called the averments. So while these averments, these are statements that are being raised in the charges, they contain a reference to what the words of the oath are. This court finds that the incorporation of the United States and Georgia constitutions is so generic as to compel this court to grant the special demurrage. On its own, the U.S. Constitution contains hundreds of clauses, any one of which can be the subject of a lifetime study. So you're saying you asked them to break the Constitution? What part of the Constitution would you ask them to break? What part of the Constitution? The 14th Amendment? Article 2? What are you asking? What part? What part of the Georgia state Constitution was Trump asking him to break? Academics and litigators devote their entire careers to the specialization of a single amendment. To further complicate the matter, the Georgia Constitution is not a mere shadow of its federal counterpart, meaning even though a lot of the terms are the same, it does have different meaning, the Georgia Constitution. And although some provisions feature similar language, the Georgia Constitution has been interpreted to contain dramatically different meanings from the United States Constitution. This is in marked contrast with, say, aggravated assault with a handgun, which can be perpetuated in only a limited number of ways. And an indictment that merely refers to a handgun is not too vague, because it infers that the weapon was used as either a firearm or as a bludgeon. Once you tell that there's aggravated assault with a handgun, I know, okay, what did he do? He either shot the guy or took him and smacked him over the head or threw it at him, but in some way, you can figure out, you can understand what he's saying. That's very different from saying he broke the 14th Amendment. What the hell does that even mean? There's so many different ways that could apply. The court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it is alleged in abundance. However, the lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. Oh no, Nathan Wade made a terrible mistake. A fatal flaw. That's a word that when you're reading that, you're like, Who would have thought that Fani Willis would be dating a dude who wouldn't know how to draft an indictment? I would assume that she was going to go for only the best, and only someone who's really capable of properly drafting RICO pleadings is someone who would be in her rotisserie of people that she would date. But apparently, she's not very she's not very discerning in her tastes, and she ended up choosing a dude who's not very good at RICO crimes. Oh well. Not wrong. As written, these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission. Didn't say how they happened. The underlying felony solicited, i.e. the underlying felony solicited. They do not give the defendants enough information to prepare the defenses intelligently, as the defendants could have violated constitutions, and thus the statute in dozens, if not hundreds, of distinct ways. You just throw a whole bunch of crap at the wall, and you're like, defend this, Trump, defend this. Here's a whole bunch of crap on the wall. We're going to charge you with crimes. You did crimes, so now we're going to punish you for crimes. Which crimes? Solicitation. Solicitation to do what? To break the Constitution. Break the Constitution how? Oh, all the stuff you did. So what the judge is like, he's like, look, you threw out a whole bunch of crap on the wall. The wall's all covered in crap you threw up here. There's arguably enough there. I mean, it seems to be a lot of stuff there, which might be to do a crime. You need to tell him which crime he's doing. That's why we have special demurs. Under the standard articulated by our appellate courts, the special demur must be granted, and counts 2, 5, 6, 23, 28, and 38 are quashed. However, these pleading deficiencies do not apply to the corresponding overt acts listed in count 1. Specifically, overt acts 23, 42, 55, 102, 112, and 156. Overt acts alleged as part of a conspiracy are not held to the same pleading standards as statutorily based offenses. So, these are the parts that he says these are still remain for purposes of the RICO. What do we got here? 23, 42, 55. 23, 42, 55. 23, 50, 42. Oh, God. $400. Oh, my gosh. What was it? I knew this was going to happen. What was it? What was it? Dang it. 23, 42. All right, let's find. We're going to try and find what Act 23 is. Why is this not working? Act 23 is this act here. On or about the 3rd day of December 2020, Giuliani, Eastman, Janet Ellis, Ray Stallings, Smith committed the following felony act: solicitation. Committed the felony offense of solicitation violation of oath by public officer in Fulton County by unlawfully soliciting, requesting, and importuning certain public officers. So he's saying is that these acts over here, it could be part of the RICO, even if it's not part of, you can't be charged standing alone. That's wild. Because they solicited various members of Georgia Senate and Senate Judiciary Subcommittee meeting, these various senators to engage in conduct constituting the felony offense of violation of oath of public officer by unlawfully appointing presidential electors from Georgia in willful intentional violation of terms of the oath of said persons. So each of these individual offenses, they will work toward helping with RICO, with the RICO charge. Interesting. All it requires is reference to the overt act. And even then, a defendant can be found guilty of conspiracy even after acquittal of any overt acts alleged have been committed by that defendant, as long as at least one overt act is proven to have been committed as by a co-conspirator. Defendants have not provided any authority requiring that the particulars of an overt act be alleged or subjecting overt acts to standards of general, special demurrers. Defendants' challenge of these overt acts is therefore denied. So ordered this 13th day of March, 2024. So what does this mean at the end of the day? What does this mean? What does this mean? What this means is that those 6 charges are gone individually. Does this mean we're not going to hear about the phone call anymore? Then find me the votes. Well, they'll still bring it up in the context of to support the RICO. Will they bring a superseding indictment to come after Trump? Well, by my estimation, this order came out roughly 14 hours ago. So we can be very confident that in the last 14 hours, Nathan Wade has racked up about 31 hours of billing, 32 hours of billing, trying to rectify this problem. Will he actually reconvene? What they can do is they can reconvene the grand jury and reassert these charges if they're so inclined, be more detailed, be more specific. They may decide not to do that. The reason to not do that would be because they might feel as if there's enough here to go after him on, and do we want to have everything be delayed by having those charges? We can still have the political benefit of talking about the phone call and all these other acts that they were alleging were illegal, and talk about them in the context of the RICO. So it's not like at first I was thinking they have to bring a superseding grand jury indictment. They're going to have to reconvene the grand jury and get these charges up there, because one of the things we know politically they love talking about is the whole fine me the 11,000. I don't need you to do all, find me 11,000 votes. All that stuff they love throwing out there. If that's robbed of them, if they're stripped of that in this case, they would convene a new grand jury to get that back. I'm very confident about that. So my initial thought was they're probably going to reconvene a new grand jury, assuming that they're not thrown out of the case. They're probably going to reconvene a brand new grand jury. Then I thought about it some more in the context of, since they still have it there, would they want to have additional delays by having a superseding indictment and then go through discovery on that or other issues on that? Maybe. I'm less positive that they're gonna try and remedy it. But I'm just saying, yeah, you know what? So now we're down from 41 charges to 35. There's plenty of meat here, and we still can talk about all these things in the context of RICO. Plus, there could be a downside for them, a downside in that it's advantageous to not have to detail these issues. It's advantageous, especially when you have an attorney like Wade who's easily confused. It's advantageous to not have to be so specific and let the judge sort of help you along through it. Look, I don't think Wade is going to stick around here much longer. Frankly, my gut tells me that Willis is gone too, and that this case is about to be heading into the orphanage. Okay, this case I think is destined to the what's it? The general prosecutor. I keep forgetting. What was it? What did you call it? You had the right name for it before. General Prosecuting Attorney's Counsel. Again, if you join late, if a case loses its district attorney, because district attorney is removed from the case, it goes to this group called the Georgia Prosecuting Attorneys Council, and they try and find some district attorney's office from a different county to pick up the case. It's not so clear that they're going to find someone so fast who's going to be happy to take this, because this case is backlogging a lot of crap. It's a hassle, it's expensive, and it's politically dangerous if you're even a purple county. So there's a really decent chance that if Fani gets thrown off this case, it's gonna basically be sitting there with little orphan Annie, singing "It's a Hard Knock Life," because it's never going to go anywhere. You could just stay with the General Prosecuting Attorneys Council and you never find anyone's willing to pick it up. It's an interesting question that McDougall fielded that he admitted he didn't know the answer to as to whether statute of limitations continues running once it's there. Like, what's the status of the statute of limitations with respect to it? Or the right to a speedy trial, if it's still out there? Can you move to have it dismissed if you don't get a speedy trial because it's left languishing with the Georgia Prosecuting Attorneys Council? I don't know. These are interesting questions of law. But first, we need that to happen. First, we need to have Judge McAfee saying that not only is Wade gone from this case, but Willis is gone from this case. Will that happen? My gut says, yeah, I think that will happen. I think she's gone. Okay? I think she's gone. That's my gut. That's my gut. Don't know, but that's my gut. If McAfee boots Fani, the case is dismissed and gone. Trump wins in 2024. Is there a conflict for Trump to appoint him to a federal judgeship? I don't see why. I don't think so. I don't think that would affect anything if he was so inclined. Why hasn't Wade been before the ethics committee? I don't know. These processes tend to take a while. It's not like someone commits a violation, even if they tend to take a while. There's likely a lot happening behind the scenes that we wouldn't know about. It's hard to imagine that no one in Georgia has filed anything against him. So yeah, I don't think if a complaint was filed with an ethics committee against Wade, these things tend to take 2 months. And even then, its publicity is, whether it would be made public, that's a question too. I think there's a strong public interest in it, but I can't tell you that it is happening. I'm simply saying, if it's happening, we likely wouldn't know about it. Unless someone was proudly coming out and saying, I filed an ethics complaint the way that Kramer did. And he tried. He did good work, Kramer, especially for a layperson. We almost got a hearing. It didn't happen, but, Joe! Did TikTok get banned? We need our member of the press to dig the truth for us. Is the death of the First Amendment. Is it the death of the First Amendment? No power to government. Okay, so I've been really, really racking my brain about this bill. In case you're unfamiliar with it, the House passed by like a 350 to 70 margin or something like that. The House bill 7248. Sorry, nope. Sorry. House Resolution 7521. I was confusing that with something different thing. It's House Resolution Bill 7521. In case you think I'm not on top of it, boom! I actually had it pulled up here. Protecting Americans from Foreign Adversaries Controlled Applications Act. This is it. It references House Resolution 7248. It references it when it talks about what nations are considered hostile adverse nations, or something to that effect. Foreign adversary nations. So, what this bill does, essentially, if we break it down, and I don't want to spend forever going through this bill, but what essentially is designed to do, as far as everyone understands it, is designed to basically force TikTok to sell at least their American interest in to the extent that TikTok is here, that they should say that it should not be Chinese owned, which currently it is. And what it basically says is that it should be unlawful for an entity to distribute, maintain, update, or enable distribution, maintenance, or updating of a foreign adversary controlled application by carrying out within the land or maritime borders of the United States any of the following. You can't provide services to distribute, maintain, or update such foreign adversary controlled application, which would mean basically TikTok, including any source code of such application by means of a marketplace through which users within the land and maritime borders of the United States may access, maintain, or update such applications. So anything that is a foreign adversary controlled, nowhere in the United States would you be allowed to provide services to distribute, maintain, or update that service. In this case, TikTok. You also can't provide internet hosting services to enable the distribution, maintenance, or updating. So you can't basically do anything related to TikTok. You can't host anything that has TikTok. You got to basically get rid of TikTok, right? Or updating of such foreign adversary control application for users within the United States. In the case of the application that satisfies definition of a foreign adversary control application pursuant to Section G3A, on that day is 180 days after the enactment of this act. So it would go into effect in 6 months. So basically, if this gets passed within 6 months, TikTok cannot be operated here in the United States unless it is sold out from China. There are 4 countries that are listed as foreign adversaries. There's a reference here. You're going to see it down below that for purposes, they say it is Section 7248. Where was it? They even say foreign adversary control application. The term foreign adversary control application means a website, desktop application, mobile app, augmented or immersive technology, operated directly or indirectly by any of ByteDance Limited, TikTok, a subsidiary or successor or an identity class, or a cover company that is controlled by a foreign adversary and that is determined by the president to present a significant threat to national security of the United States following the issuance of a public notice proposing such termination. See, now this is very interesting that they specifically identified TikTok in this. It's very interesting that they specifically, and people have concerns that this will apply to other social media like Twitter. Now, I'm not aware of Twitter. This applies to any companies that are owned by have a 20% ownership in any of these banned countries. The 4 banned countries are North Korea, China, Russia, and Iran. Those are the only 4 banned countries on the list. If the company that's operating has at least 20% ownership, you can't basically run a website through here. So a lot of people have questions like you're asking. Russian bot, is that the death of the First Amendment? What do you guys think? It's an interesting question. It's a very, very interesting question. When this first was discussed in Montana, I spent a great deal of time talking about the right to hear, as opposed to the rights of free speech, the right to hear. I don't want to just go through it all over again.
But the point I was making is, a lot of times when we're talking about what the right of free speech is, so the question comes up as like, why do we need a right for free speech? What's the objective of right to free speech? Is it that you should be able to get something off your chest? Or is it that we as America need to have a right to access information from any source? If instead of it being TikTok, imagine 150 years ago, there would have been a boat that came in here, which was filled with all sorts of literature, which was basically promoting people to injure as many Americans as they could. And that was all this different literature, a boat coming in here, which has basically, that's coming into a dock, and we know it's filled with these different pamphlets, whatever, books, and it's got on it a million books, which are basically they're planning on basically distributing for free around the country, which basically encouraging people to delete as many Americans as possible. Would you have a right? What is your right of free? Does your right of free speech entitle you to hear it? I don't know. That's your right to hear. I think your right to hear could be labeled. Your right to access information could be labeled a protected right, but I don't think it's expressly enumerated. I don't think it's the same as your right to free speech. Your right to free speech is arguably far more powerful than your right to hear. Now, those people who have TikTok channels, that's where you start getting into a different thing. I want to be able to speak on this platform, and I can't, and you're violating my free speech rights. The other issue is as far as, free speech rights of anyone who's, let's say, a Chinese national living here in America. Let's say who owns TikTok. Are they normally would have free speech rights? I think that this is definitely going to be challenged before SCOTUS. If it passes, it's going to be challenged. You can understand the concept of not allowing in subversive messaging in certain contexts, couldn't you? In times of war, wouldn't you say like stuff that's designed to depress morale? That's something that like you can understand, I think, how it might be an unhealthy thing. It's a very, very tough question. It's a very, very tough question. I'm not as against it as probably many of you are, but I'm not sure that I think it's okay. I'm really, really just, this whole TikTok ban, part of the reason I didn't really get into it is because I don't have a strong feeling on it one way or another. There's in certain ways I can understand it and recognize that this, when applied properly, is logical. And in other ways, I worry that I don't want to give government control over anything that I'm able to access. And that's not a slippery slope toward free speech violation. That's like a super slide toward free speech violation. So that's why I'm very torn about it. Joe, have fun figuring out if Fani needs to go back to grand jury to be able to charge information only. I think she would have to go to grand jury. From slightly criminal in Georgia on major felony, you need grand jury to recharge it. That's what I thought. I don't know who slightly criminal is, but that's basically what I said. Where do you think I got that wrong? No DA in Georgia is picking this up. I think you're correct, J-Rock. It's a political football, which is like, it's like waiting to blow up in your face. China Ray owns a great part of the U.S. I think that's true too. And I think that banning China from being able to control America is a logical perspective to take. I think it's a very, very logical perspective to take. I would be totally fine with a law which says that no foreign government can buy property in the country. I'd be totally fine with that. Then you got to start parsing out when does something become part of a foreign government. That's a different thing also. especially when you're dealing with some of these fascist or these fascist states or these, communistic states. The bipartisan support sets off red flags. Yeah, that's true. Definitely. It has a very uniparty feel to it. Maybe they want U.S. government proxy to take over, like Facebook directing Facebook about, like the FBI directing Facebook about the laptop. Yeah. I definitely agree with you about that. It feels dystopian. It feels very unsettling, very uncomfortable. Is it okay to burn books? I don't know what you mean. I mean, I understand what you're trying to say. I don't know that that's really I don't know that that's really. If it's not okay to burn books, so you need to sort of come up with, okay, why is it not okay to burn books? Like, it's not like, is it okay to do this? You have to ask. You have to basically think through intellectually what is wrong with book burnings. And I'm not trying to say that book burnings are okay. I'm simply saying, okay, so if you're going to say that book burnings are bad, then we need to sort of figure out why are book burnings bad. And is it the violation to the author and his ability to speak, or is it a violation? Is it something that's an affront to you're depriving the hearer? And again, I'm not saying it's okay. I'm not saying that book burnings are okay. Definitely not. I'm simply saying that we have a better understanding as to what we're actually saying if we think through these questions in ways that we have a better understanding as to what is the impact of the activity that we're describing. And I can appreciate how book burning is similar to banning TikTok. It's okay to burn books. Yeah, I don't like the idea of burning books. I'll throw this back at you. What if those books are basically CP? Let's say you have books that are all CP. Would you say that should be something that we should never burn? Because if you told me you have like a stack of books that are CP, and you want to basically light them aflame, I'll bring the matches. So, can I just give a generic like, oh, okay, book burnings by definition are wrong? No, I wouldn't say that they're by definition wrong. So then you have to ask them, okay, so what is it we don't like about book burnings? And so we can try and figure out where would book burnings be. Does anyone disagree with me that burning books with CP is okay? That's an acceptable thing to do with CP? So now, and what's the problem with and then we have to sort of break down, okay, so if we can come to a consensus that burning CP, and in case you're not sure what CP, C normally stands for child, and P normally stands for something that you should never be associated with the first word. So if we're talking about burning that, I think most of us would agree that's okay. And if you're with me on that, then you have to ask yourself, okay, what makes that okay in my mind versus general book burnings that I think are terrible, awful, terrible, terrible, awful. And so you need to figure out in your brain, so you can figure out, this is a healthy way of examining your own morality and this is how you sort of figure out where you stand on things. So to me, if you ask me, I'm not telling you what the law should be. What I would say is I can understand saying that something that is purely self-destructive, like I don't think that the reason CP should be burnt is exclusively because of the harm to the people who were photographed in those books. That's not the only reason. And perhaps that would be the reason you would say it's okay, that you're protecting the kids who are basically portrayed in that stack of books. And perhaps that is the reason why you would agree to it. But I think the idea of promoting that as like a healthy perspective is so base and so self-destructive to society that the idea that this is something that's like, you know what, I don't want this being promoted as being something that's tolerable. I can understand people just being like, no, 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 just no, no, absolutely not, no, no. So I can understand the idea of someone saying, I don't care if these are pictures of people who didn't know the pictures happened and these pictures are 100 years old and they're all dead. So it's not affecting them, they never even knew it happened, and it's not having any impact on them. Or it was even just AI and they never even happened. But it's just portraying it? No, I'm totally fine. If it's pictographs, which are just drawn, really well drawn, and you have a stack of that and someone set fire to it, I'll get the matches for that too. So it's not the victims. I think most of you would agree you bring the matches for that too. And if I'm correct in that, then you have to ask yourself, what makes that different that we would be okay with burning that compared to other stuff? Here's another thing. Yeah. So, and because that's the next thing we can go to here, which I think is it's healthy for purposes of discussion to sort of understand morally, psychologically, emotionally where we are on certain things. So now, if you tell me that instead of it being a book of actual CP, but it's a book basically encouraging 5-year-olds, kids 5 and under, to be seeking out that they should be changing their bodies through drugs and chemicals. Because I'll tell you right now, in a heartbeat, I would burn that too. I would burn that in a heartbeat. So now we're talking about peddling influence, which I think is self-destructive and designed to harm society. Now, you can call me draconian in saying that. I'm telling you right now, I would burn that in a heartbeat. So, you tell me, like, are we really sure? So now, assuming TikTok is, and I'm not saying that they are, because I don't think that they are. I don't, the devil that Congress is playing it out to be. I've scrolled through TikTok. I don't think it's nearly the devil that they portray it to be. I'm simply saying, so I don't. So in that sense, like the application to TikTok, I'm like, I don't like it. Like my gut says I don't like it, but I'm not like freaked out about it. I'm not freaked out about it because I do look at it as it's a playground for destroying young minds. So in that sense, so now with respect to destroying a 5-year-old's mind and motivating that 5-year-old to start taking drastic steps to change their entire body and telling them you'll be really successful if you change your body, that I would happily burn that. Now, if instead of that, I'm looking at TikTok and I'm walking to the next step here, and they're basically poisoning their minds with similar ideology to 9-year-olds, not 5-year-olds. But they're much more sinister about and insidious in the way that they do it. Where they're basically like, oh, okay, if you're a loser and you have no friends, you know why that is? It's because you're in the wrong body. And if you change bodies, everyone's going to love and accept you. Now, are they saying that directly? No. You just see that anyone who basically promotes that type of ideology gets tons of likes and clicks and love. And all of a sudden, if you're a loser, you feel like, hey, that's an ideology. If I support it, everyone's going to love me. And wow, if I go one step further and I actually jump in and start thinking about changing that, maybe that is the reason I'm not so popular, is because I was born in the wrong body. If I show everyone that I'm changing bodies, maybe I'm going to get a lot more love. So you're telling me that absolutely this is to get rid of that perspective from infesting young minds, that's a terrible agenda. I don't call that like the end of times terrible agenda. This is why I've been very, I don't love, it's like depending on what time of day it is when I'm looking at this whole TikTok thing, I'm very, very torn about it. I'm very, very torn about it. Because like BS is saying here, the first knee-jerk reaction is, no, it's not okay to burn books. What the hell's going on here? And that's what this is. This is a book burning. But then I start thinking, you know what? Some of the books that have been coming out pretty recently, they should be burned. So I don't know. This is how much this is. I know that if I say something, that my opinion on this is going to some people, my opinion on it is going to carry some serious weight. And that's why I'm saying I don't want to just throw an opinion when I'm so torn about it and then push people to coming to a conclusion that I might disagree with myself a week from now because I'm so torn about this. I'm very, very torn about it. And like H. Coffee says, when you have both sides of the aisle on board with it, you got 350 votes in Congress right away. I'm like, I don't like the feel of that at all. Something feels really wrong here. Something feels 350 members of the House agree with this. I don't know about that. Something's wrong. Something's wrong. I don't know. So that's why I'm very torn. I'm very, very torn about it. And I don't like weighing in on things when I'm very torn. Maybe I'll look, you know what? Maybe a week from now I'll feel really strongly about it. Someone make a compelling argument to me one way or the other, and I'll be like, yeah, that's true. That's really true. That's a great point. You're right. That's why I need to be in this camp, or that's why I need to be in the other camp. But right now I'm very, very torn on it. I'm sorry if it was mentioned earlier, but this was a single topic HB. Can they, I don't know, do that with other things? Maybe that's all I'm thinking about. It would be great, right? It would be great. It would be great if that happened. H. Coffee says, also turn on this. Dislike foreign influence. Yeah, I'm very bothered by the idea of foreign influence, but don't want to give government more unnecessary power. Yeah, I don't like any of them having power. Yeah, exactly. We as ordinary citizens can't prevent China buying land, but we can fight the information war online. Yeah. Everything he just said. Totally agree. Or she. I never found out if H. Coffee is male or female. I don't care. I just care about the fact that H. Coffee spits facts and logic. Joe, your guess for how many leftist heads will explode if Musk buys TikTok? Imagine how amazing that would be. They would be so. That'd be the best way to clean house. That'd be the best way to clean house. Because all the kids will leave. Just flee. Flee. Run away. Run away. Run away. Oh my God. I think, like I said, I think Anna could be correct on this. I've gone through TikTok, okay? A bunch of accounts that I've followed on TikTok. I even have an account of my own on TikTok where I've dropped like 3 videos ever in my life. The most recent video I dropped was 2 years ago where I said, okay, I'll start making more videos. Seriously, I'm not even making that up. That's the most recent video I dropped. It's at least 18 months ago. I think closer to 2 years. And I was like, the first video was like, why are you following me? There's nothing here. And then the next one was like, okay, I'll make more videos. And that was it. That was 2 years ago. So, but yeah, I check out like some football stuff on there sometimes, which is like like things joking about football. There's a guy Brand who I follow there. You know, and I've never seen any of the craziness that people talk about on TikTok. But they say I don't know. And the they in this context are people I never trust. So I do see a lot of woke leftist kids there, though. I do see that. TikTok is a brainwashing app. Maybe. It can't be healthy. It's definitely promoting more ADD, where it's like you're just constantly flip. It's like, this is not a healthy way to spend 7 hours. I don't know why I keep doing it. Today, we're creating modern day eunuchs. Yeah, that's definitely true. China has banned TikTok in China, but once in the US, that's a red flag. Unban in China first, then we can leave it alone. Yeah. And then they throw back at us. It's like, so what are we, the next China now? Maybe we just take lessons from China as to like what China itself doesn't like about its own messaging. This feels like Patriot Act 2.0 Primrose Path. Yeah. Another fair point. Is along the lines of what H. Coffee was saying. Is like, I don't trust the people behind this. I don't trust it. So there you go. I'll throw a quick. I'm curious where you guys stand on this. I'm gonna throw it up there, and you guys tell me: should we ban TikTok? Should TikTok be banned in America? I have no idea how this is going to end up going. Where is it? Sorry, let me. Yeah, I heard that Bongino. Thank you, Kimmy. I heard Bongino said that Rumble was interested in buying like the American division of it. I almost just sent myself a super chat. Wow. Okay, I'm not thinking. Start a poll. If Rumble bought it, you think that would become a better place? Because I have no reason to think it would. Simple question. Should we ban TikTok? Yes or no? Let me check over here. You folks in the ghetto. Entry required. Good Lawgic. Fellow New Yorkers smashing the like button early this morning, almost 6 a.m. here in Sweden. Hello to the following, Mr. Entry required. Thank you so much. I want you to know, Entry required is the first person who pointed out to me that I really should share my source material in a separate link on Locals, which is I started doing now for subscribers. It was at his behest. So, hello, Sweden. Phil Pease says, if Congress can all of a sudden come together and push a bill out like this, it's because it's in their interest, not yours. Yeah, I definitely agree that that's a possibility. So what's the end game, though? Why, let's assume that all of our concerns about Congress have proven to be correct time and again. What do you think their end game is? What is their reason? What self-interest are they displaying by banning TikTok? Because I can't figure out their angle. I've struggled. I've been trying to figure out their angle, and I can't figure it out. I don't know. All right. Let me see where this poll ends up. I'm going to ask in Rumble. In Rumble, if you think we should ban TikTok, say put a 1. Ban 1 for ban, 2 for no ban. One for ban, 1 for yes ban TikTok, 2 for do not ban. As expected, a lot of 2s over in Rumble. Oh, I want to try something. That reminds me. I'm going to try something new. Give me a second. This is going to be so cool. How do I do this? Try something new. That didn't work. Give me a second. Oh, wow. Can I add background music here now? Try this. Okay. Interesting. All right. Someone created for me this really cool thing. I just gotta show you. I thought this was the coolest thing. Check this out. I know you don't see it yet. You will in a second. Let me make this bigger. Well, that's not working. Oh, that's disappointing. All right, I know I'm boring you all. I apologize. Look at that. Look at that. Look at that. Is that the coolest GIF that Zero FUX made for me? It's gonna come back. That's what's supposed to be running across my screen here. He made it for me today. That is the coolest thing in the world. It's coming back. Don't worry. Look at that. That is so wicked. That is so wicked. Oh my God. That is just amazing. I thought that was the coolest thing in the world. Yeah, I don't know how to that is the coolest thing. I could watch this all. It's a GIF. It's not a GIF. Okay? It's a GIF. A GIF. I don't know. Yeah, I want to. So I need to figure out how to get that to run across the screen here while I'm talking. I was just trying to do it and it wasn't working. But yeah, please subscribe. Please subscribe. I appreciate that. Really cool of you. Allegan says TikTok should not be banned, but age limit without parental consent and right private action against company without consent. I don't know how you do that. I mean, does that really just slow down anyone? Because I don't think it does anything. The bill gives the president the power to determine if an app is essentially acting as a foreign agent, even if it's domestic, and to ban it. I personally think it's Biden's way to eventually ban X. And this is what I think a lot of people have concerns about. That it's designed to basically pave the road. That is the end game everyone has concerns about, that it's basically designed to shut down X. It's very hard to figure out how it would apply, how they would twist this into a ban on X. It's very difficult to figure that out. Because everyone has that concern, and you should have that concern. It's hard to understand how they would do that, though. I mean, Elon's an American. So it's very hard to figure out how they would do that. I don't know. Anyhow, I think it's time for me to start wrapping up. So I'm going to do that. Let's wrap this up. Tomorrow I'm going to be covering on goodlogic.locals.com. I am going to be covering, I'm going to be finishing, God willing, the Tucker Chris Como interview discussion, because I thought that was a really great discussion. So I urge you to join me for that, because I think you're going to enjoy it. I'm positive. I'm very confident I'll enjoy it, and so will you. That's at goodlogic.locals.com. Wherever you are right now, whether it's in Rumble, whether it's on TikTok. I'm not on TikTok. I mean, I'm on TikTok, but I'm not streaming there. Whether it's on YouTube, on Rumble, you're watching me on local, whether you're watching wherever you're watching me on X. If you're on X, you're one of those X people, you're watching me on X, just like, follow, do all that stuff, share. That'd be much obliged. That's my show for tonight. I thank you for joining me. Oh, wait, a couple more. The argument basically is that Americans are empty-headed consumers who cannot think for themselves, thus everything not under government should be banned. You DM me that part of the bill? You DM me that part of the bill? Let me see what you got. Yeah, I don't think that that's accurate. I think that this is exactly sort of, this I think is misinformation. And I know that's what you were sharing. You didn't come up with this. This is what Patrick Webb shared out. And a few people shared out. I think that this is a mistake. Covered company means, the term covered company means an entity that operates directly or indirectly through a parent company, subsidiary, affiliate, website, desktop application. That doesn't mean anything. That doesn't mean anything. They just don't want it to be excluded just because it's at a website. That's not more of a Twitter thing. That doesn't do anything. Both TikTok and Twitter operate as websites. Almost every app operates as a website also. Most of them do. I think that the whole key is that it's only applying to companies that are at least 20% owned by these foreign agencies. So that's what this is. That I don't believe that applies to Twitter. Unless all of a sudden, China buys up 20% of Twitter's stock. Imagine if that happened. Maybe Congress has. But everyone's. It applies to Facebook too. Facebook is a website. I think that this thing was raised to confuse people, and that's not an unusual thing for them to put in the bill. That's my personal take on. That's my personal read on it. I don't know. People might read it differently. My read on it is that that's not something that's more indicative of an attempt to take down Twitter. I've seen a bunch of people say that, and I don't understand intellectually the argument. And perhaps this is true. And I definitely don't want to see X go away. Anyhow, I thank you all for joining me. Tomorrow I'm going to have a stream on locals. Make sure you follow me there, goodlogic.locals.com. I'm going to urge you all to stay happy. Please find foreign ownership in publicly traded companies. Talk about 20% being owned by a national. The bottom part is the concern. Mobile application. The bottom part is the concern. The bottom part there says desktop application, mobile application, or augmented or immersive technology application that permits the user to create an account or profile to generate, share, and view text, images, videos, real-time communications, or similar content. Has more than 1 million monthly active users with respect to at least 2 of 3 months preceding the date on which a relevant termination of the president is made pursuant to paragraph 3B. Yeah, so you're saying termination of the president enables one or more users. Hold on a second. So more than 1 million monthly active users with respect to at least 2 of the 3 months preceding the date on which a relevant termination of the president is made pursuant to paragraph 3B. You make me go back to this. What was 3B? Okay, now I'm going back. Now you intrigued me. Now you intrigued me. You intrigued me. I was about to walk off. Foreign adversary control application. The term foreign adversary control application means a website desktop application that is operated directly or indirectly through a parent company by any of ByteDance, TikTok, a subsidiary or a successor to identify to an entity identifying clause 1 or 2 that's controlled by foreign adversary, or an entity owned and controlled directly by an entity or identifying clause 1, 2, or 3. Or a cover company that is determined by the president to present significant threats to national security of the United States following the issuance of a public notice proposing such termination, and a public report to Congress submitted not less than 30 days before such termination, describing the specific national security concern involved and containing a classified annex and description of what assets would need to be divested to execute qualified divestiture. Ooh. Determined to present significant threats to national security of the United States following the issuance of a public notice proposing such termination, and a report to Congress submitted not less than 30 days before such termination describing the specific national security concern involved and containing a classified annex and description of what assets would need to be divested to execute a qualified divestiture. Yeah, that I don't know what the hell's happening here. Okay, that I have a problem with. That I have a real problem with. That I have a real problem with. Okay. Okay. Yeah, this is bad. I don't. This is. All right. This is making my stomach turn. Okay. I want to discuss this with a few other attorneys as to how they understand this would operate. I really want to think this through. Okay, now I'm bothered. Now I'm concerned. Yeah, the president should not have any kind of power like this to just shut down a company. Yeah, okay, that's very disconcerting. All right. Thank you. Thank you very, very much, Anna. When you get both sides, when you can get both sides to agree on something, it usually means taking away more rights, like the Patriot Act. That's what Anna P was saying. It's Patriot Act, but it's more vague and widespread. Yeah, that was gross. That was gross. I don't like that at all. I don't like that at all. Thank you, Mr. Dennis Pocket. Consider any impact on Proton Mail, Telegram, VPNs. Yeah. No, this is the fact that you can just label something the president considers an enemy, and now all of a sudden this would go into effect. Yeah, that's kind of crazy. That's kind of crazy with very little guardrail. What I was bothered by is there's almost no guardrail. There's almost no guardrail. That's very, very disconcerting. It also feels like habeas corpus. Like you just attack a company like that. I want to think on this more, but that's a very, very that's very disconcerting. That's very, very disconcerting. All right. Thank you. See, I told you. This is why I didn't want to weigh in, because I sort of was like, let me see. Let me think this through. I don't like just jumping in because something just I want to sort of assess in my brain. That right there, if they left that part out, I'm like much more okay with this. But that I can't. By that I cannot abide. I cannot abide by that the president would have that kind of power to shut down a company because he deems it a threat, because they're all full of crap. Foreign adversary, and yeah, no, you're right. You're right. You're right. You're right. Love your show from California. Oh, thank you, Slap Happy. You're too kind. I feel as if I lost my way the last few minutes because I'm sitting here trying to figure out this TikTok bill. All right. All right. It's funny, you know, I was actually invited on before I wrap up. I was invited on. I never responded by Mario to sit on a panel and talk about this TikTok bill. And I was like, I don't really have strong feelings on it. And I was like, they were having this thing at 4 p.m. to discuss the TikTok bill. And I was like, I don't really know where I stand on this. I really want to think this through. Well, you guys have done an effective job. Effective job telling me that in its current form, no, that's a no-go. That's a no-fly. In its current form. In its current form, that's definitely a no-go. If they cut out that part about the president, then it merits thought. Then it merits thought. But just to give him carte blanche to do that, no, that sounds crazy. That sounds crazy. Because he could just pick any massive company and shut it down. I mean, it has to be a million users per whatever per month, but okay. It would be Telegram. It would be Gab. All of a sudden, you know, they'd shut down Gab if Gab's big enough. They shut down Rumble. They say Rumble's big enough. Yeah, that or X. Yeah. Okay. All right. I don't know how that part got through Congress with such big numbers. The hell's happening? What is the history which led to freedom of press? Something about kings destroying printers, freedom of mass communication, internet is press, in my opinion. And that's a fair point. But that's freedom of speech, not freedom to hear. That was my issue with that. You say it feels like a setup. It gives Biden the opportunity to veto and save the day for all the young voters he's been bleeding. GOP is clueless again. I gotta tell you this. They ban TikTok. That will piss off the kids. That will piss the kids off. That would piss them the right hell off if they ban TikTok. Right? A private action versus President of the United States. Look, I do think that this bill would stand. It's going to stand. There are going to be issues with it, both with respect to habeas corpus and with respect to freedom of speech. In fact, there was a whole Montana case which was basically saying you can't do this. It was the decision of Montana which said you can't do this. So, I don't know if this is going to withstand court scrutiny anyway. But in its current form, giving all that power to the president that's messed up. That's completely messed up. I can't believe I've been here for 2 hours. Good golly, it's 1:30. I need to shut down, my friends. I thank you for joining me. I'm going to urge you, stay happy, eat some bugs. Don't eat some bugs. That's the new thing. Stay happy and do not eat some bugs. And as always, my friends, I say to you, good night. See you tomorrow. Sleep well. And Godspeed. I'm still here. What the heck? I'm still here. All right, now I'm out. I was checking locals. That's really what it was. Godspeed.